Good evening, everyone. Can you all hear me? Good evening, everyone. Can you all hear me? Please, can someone confirm that I'm being heard?
Good evening, sir. We can hear you. I can hear you, rather.
Thank you so much, Obafemi. Thank you so much for confirming. Not to waste any time. All right, welcome. Good evening, everyone. Welcome to the JIIPCC Mentorship and Internship Program Week 2 of the third and fourth quarter 2024. Right. Not to waste any time with plenty talk. My name is Dennis Williams, and I will be your moderator for today. So moving on, our topic for today is data processing, transfer, data collection, transfer, and control. So we'll be doing well to just introduce the mentor that we're expecting in today's class. Okay, I can see Mr. Ridwan is already with us. Thank you so much, sir, for joining. Right. So moving on, sorry. We'll be reading the profiles of the mentors that we're expecting on this call. So firstly, we'll be going to Mr. Solomon Okidara. We hope that he's going to be able to join in the call today. So Mr. Solomon Okidara, barrister and solicitor of the Supreme Court of Nigeria, is a practicing legal practitioner sorry for that. Solomon Okidara, barrister and solicitor of the Supreme Court of Nigeria, is a practicing legal practitioner and researcher with over 14 years post-call experience and outstanding expertise in human rights with special bias for digital rights, including data protection and privacy, data identity, online expression, intellectual property, e-commerce, tech and corporate transaction, and artificial intelligence. Having an unusual knack for excellence and matchless client satisfaction with a view of delivering maximal results, armed with a peerless ability in creative legal research and analysis, delivering impressive results in review of law, legal principles, and standards. Solomon is a partner at Solomon Okidara & Co., and a firm of barristers and solicitors, and co-founder Digital Rights Lawyers Initiative, a not-for-profit NGO that focuses on promotion and protection of digital rights. Solomon is a strategic litigation lawyer with a robust interest and proven expertise in freedom of expression and data rights litigation. He has litigated on data rights and freedom of expression subjects in courts across Nigeria up to the Supreme Court, and he has conducted cases at the ECOWAS Court, amongst others. Solomon was in 2020 recognized as one of the top 50 individuals leading in legal innovations in Africa at the Africa Legal Innovation Award. Solomon currently serves as a legal researcher with Columbia University in the city of New York for the Ivy League School Global Freedom of Expression project, where he analyzes judgments bordering on freedom of expression, subjects covering over 120 jurisdictions across the world, including United States, Europe, India, and Africa, amongst others. He is a 2016 Research Fellowship recipient of International Center for Not-for-Profit Law, Washington, D.C. He was specially recognized in 2017 Heroes for Human Rights by Access Now. Solomon was specially recognized as a finalist at the 2018 Global Freedom of Expression Prize at Columbia University. Like I said, we expect Mr. Solomon to join in very soon. Hopefully, he will be here soon enough. So secondly, that we have for today on our mentors list is Mr. Emmanuel Ewere. Mr. Emmanuel Ewere is an accomplished information technology law specialist with a wealth of experience in guiding clients through the intricate legal landscape of technology. With over 8 years expertise in the field, he has been a trusted advisor on various legal matters related to information technology, including data privacy, cybersecurity, intellectual property, and e-commerce. Education has been a cornerstone for Emmanuel's professional journey. In 2015, he earned his call to the bar certification from the Nigerian Law School, building a solid foundation in general law. He further honed his specialization. He further honed his specialization in information technology. Law by pursuing a master's degree from the University of Tartu in Estonia. Prior to that, he completed his Bachelor of Law at Madonna University in Nigeria. Emmanuel's career has been marked by significant accomplishments, and he has held key roles in prestigious organizations as a business developer at Floorworld LLC in the United Arab Emirates. He managed various projects, ensuring compliance and due diligence. He provided crucial counsel to clients on matters such as data privacy, cybersecurity, and intellectual property. Additionally, Emmanuel's skill in drafting contracts, conducting market research, and budgeting were instrumental in driving the success of various projects. During his tenure at Adamson, Adeboro, San and Co., a prominent law firm in Nigeria, Emmanuel actively supported attorney in legal research and document review. He played a pivotal role in drafting legal memos and reports while also engaging in client meeting and negotiation. His litigation experience was an asset in court appearance on behalf of clients. Emmanuel Were is not just a legal expert, but also a tech-savvy professional. His technical skills include proficiency in Python and a comprehensive understanding of information technology systems and processes. He excels in risk management and compliance, crucial elements in dynamic world of IT law. Moreover, his adeptness in contract drafting and negotiation, coupled with a solid grasp of cloud computing, IoT, and blockchain, makes him a well-rounded specialist in the field. Recognizing the importance of continuous learning, Emmanuel has pursued various professional development opportunities. He holds a certificate as an information privacy professional and consistently engages in continuing legal education courses that focus on data privacy and cybersecurity law. Emmanuel Were actively contributes to the legal community through his affiliation. He is a member of the Nigerian Bar Association, where he actively collaborates with fellow professionals to address emerging legal issues in the tech realm. Furthermore, he is a member of the International Association of Professionals, a testament of his commitment to staying at the forefront of data privacy matter. With his impressive credentials and extensive experience, Emmanuel continues to make a significant impact in the realm of information technology law through his legal acumen and technical expertise. He serves as a reliable ally for clients seeking guidance in navigating the intricate legal challenges of the digital age. Thank you so much, Mr. Emmanuel. It was such a wonderful and lengthy, such a wonderful and very lengthy profile we have from him. But obviously, it's just a testament to his vast knowledge in this particular space. The last but not the least of mentors we is the one and only Mr. Ridwan Badmus. Kindly, please, if you're on mute, please, can you kindly? All right. So sorry about the noise in the background. Just to read Mr. Ridwan's profile. Mr. Ridwan Badmus is a tech lawyer, multidisciplinary privacy professional, and CTO. His expertise extends across various specialized technology law domains, encompassing artificial intelligence, blockchain, cloud computing, and other cutting-edge technologies. Being a certified information privacy technologist with the LAPP and the esteemed OneTrust Fellow of Privacy Technology, Ridwan is at the forefront of translating privacy regulations into functional application that handles user data, a significant void he diligently fills. Furthermore, his unique position in working across numerous complex projects bridges the gap between legal and technical teams, thereby harmonizing two distinct domains in this expansive technological landscape. Ridwan adores for the effective implementation of privacy and security best practice is evident in his active involvement in shaping industry standards set forth by eminent organizations such as the National Institute of Standards and Technology, the Cloud Security Alliance, and the Center of Internet Security. Um, right? I guess you've had all the profiles. You were able to listen through all the profiles of the mentors, and you can see that they are well apt with knowledge and experience from their end in the lines in the lines and in the lines of data privacy. They are well equipped to help us give diligence that they are well equipped to do due diligence to today's topic. So, not to waste any further time, we'll be giving the floor first to Mr. Emmanuel, if he's here on the call. Mr. Emmanuel Iwere. Mr. Emmanuel, if you are with us, please, we would like to kindly give you the floor for like 15 to 20 minutes to just help us run through the topic for today.
Hi everyone. Like you rightly said, thank you very much for this opportunity. I just want to be sure that you all can hear me.
Yes, sir,
Can
we
you
can
hear
hear you,
me?
sir. We can hear you, sir.
Okay, okay. Thank you once again for the opportunity to mentor these bright minds and share knowledge with them. I believe that it will be an interactive section where um, we will all exchange great ideas, and at the end of the day, we will all be refreshed. I won't I won't really spend much time because I'm actually on a trip, so and I'm waiting for my next connecting flight too. But I'll just make sure I maximize my little time. So now I'll start with an introduction to this whole concept of privacy data protection. Um, you and I will bear witness to the fact that majority of our conventional life has gone digital. And before now, you hang out with your friends and you create time to go for play dates and have physical contact with them. But right now, majority of your relationship with your friends and family and the rest are digital. So this is just to buttress the fact that life has transcended so much from physical and more digital right now. And because of this transformation from physical to digital, more of digital affairs calls for regulation, checks, and balance of the system of the digital world. Now, the fact that we have embraced a new fair of life calls for urgent attention to ensure that people's rights are respected even in the physical and in the digital world. Now that gives us the idea of what privacy comes about. Privacy is actually you now telling others in that digital world, yes, respect my space. And data protection now speaks on respect respect my information. So with this general and broader view of introduction, I'd like to tell you that you'll be looking at how people's people's rights, not just people, your rights can be breached, and how you can actually protect your rights as well in the digital space. So privacy, data. Sorry, can you just give me like 5 minutes? I will join back again.
Oh, okay, sir.
Please
That's
give me
very
like
fine.
I'll join back shortly again, okay?
All right, sir. That's okay, sir.
Okay.
So Mr. Iwere is kindly asking that we give him a little time. He, like he said, he's currently on transit, and he may not be too long with us. So I'll kindly ask for us to wait a little bit, so that he can just finish his presentation, and then we'll go on to our next mentor for today.
I'll be back shortly. Thank you.
Thank you very much, sir.
Hello, everyone. Can you hear me? Hello.
Yes, we can hear you, sir.
We can
Okay,
hear you,
thank you
sir.
very
Yes, yes, we can hear you, sir. Thank you.
My apologies for the short break. Just got some updates. All right, so back to what I was saying. So still on the introduction. Now I've spoken about personal interaction and now I'll look into the business world. Now in the business world, this digital this digital this digital world seems to be like a very, very big, in fact, a very booming business when it comes to data. Now, in fact, data is even described as the oil of the digital world because processing of data brings about a lot of, should I say, that is actually how they make decisions and they make profit as well. So, what does generally what does even data processing? What does data processing involve? Since that is what a lot of the business entities bank on in the digital world. Now, data processing involves collection of data, how they collect this data, and when they collect the data, what next? How they use it, and in the course of the using in the course of their usage of the data, how do they store this data? Apart from the storage, how do they process it? And sometimes in the course of usage of this data, they have to transfer this data either locally or internationally. How do they transfer it? So in order to checkmate all these processes and to ensure that they are protected, the data subjects are protected. Now, I want you to know that in the totality of all I have listed, in order to ensure that one person is protected, which is the data subject, that is the basis of all the checks and regulations to ensure that you and I, the data subject, we are protected. Now, coming to how countries have actually adopted this whole data protection and privacy. Now, the looking at the GDPR, which has actually set a framework for a lot of countries to emulate, and looking at Nigeria, our own country, that is gradually catching up, trying to meet up with the fast-paced moving digital world. So a lot of countries have tried to emulate the framework that has been set up by the GDPR, all to ensure that one person is safe, which is the data subject. So let's look at how let's look at the history of um of privacy and data protection in Nigeria. Now, this can be traced back to our constitution that has covered a bit of right to privacy, and even even though it was not explicitly it was not explicit on the digital world. Now, coming down coming down to the revolution that has happened in the digital world, we have been forced to make out regulations and even went further to enact an act to ensure that privacy and data protection, especially data protection, is well considered in Nigeria. And we, apart from that, we have plethora of judicial authorities that has made pronouncements to ensure that data subjects are protected, data subject rights are protected. So I've made mention of the Constitution, I've made mention of judicial authorities that have been in existence to ensure that the data rights of the data subject are well protected. So why do they need to protect? Why do they need to even protect these rights? Why do they even another question a layman may ask is why must they even protect? Waiting they use my data to? Why are they trying to protect my data? There are so many reasons. I'll tell you, I'll just list a few of them, but I want you to understand this I'm trying to make sure I break it down to the smallest form so that you pick the meaning, the meaning and the intent of all these. Now I'll talk on targeting and advertisement. A lot of us are aware, okay, yeah, I won't say not aware of the fact that you are being monitored and you're being fed with target advertisement. Sometimes things we discuss, things you just take by carelessly, you just get ads, you get things related to it coming to you. All this is because your data is being monitored, and because of that, they can make their decisions on what to feed you, on how to get your attention to what you have been thinking or planning to get. And sometimes, if this is not properly checked, you can be exposed to even you can be exposed to ads that will actually definitely lead to you buy buying things that are not from a safe site or not regulated. So apart from that, surveillance and spying. Now, a lot of these big companies, they they breach a lot of people's rights by spying on them, knowing their health status, know their relationship. In fact, I want you to know that you know this already when you after downloading an app. A lot of these apps will find a means to make sure you accept the fact that they have access to your contact. And by so doing, they know the people that you interact with, and they know exactly who. In fact, we have a lot of all these digital banks in Nigeria that once you default in payment, one of the first moves they will make is that they will send messages to your contact to let them know. I guess most of us were familiar with all this. So I want you to know that before sending those messages, they have been spying on you, and they're already aware of those information that were supposed to be your private information, your private property. So all these illegalities requires checks, and that is why a lot of measures have been put in place to ensure that your data, your personal information, your identifiable information is protected. And I don't think I still have much time to. Please, can I join back again before the end of this session?
All right, sir. That's fine by us, sir. Thank you so much for this little time you spent with us. We sincerely do appreciate.
I will try and connect with any opportunities that I get. Thank you very much.
All right, thank you so much, sir. So we thank Mr. Emmanuel for that brief highlight that he gave into history, what data privacy and protection is all about. Thank you so much, sir, for your time. So please, we'd like to receive Mr. Ridwan Badmus' presentation on today's topic matter, and hopefully before we go far into the session, we'll be having Mr. Solomon Okidara. So, Mr. Ridwan, please, the floor is yours. I would like to hear from you. What do you have for us today as regards our subject matter, data collection, processing, and transfer?
Okay, thank you very much. Hello, everyone. It's nice to be here again. It's always a pleasure to share insights and listen to you as well, and learn from each other. So thank you, and it was very insightful to also listen to sorry. Yes, sorry about that. I have a glitch. So yes, so it was really interesting listening to Mr. Vega as well. So it was really insightful. And I mean, it's a very, I wanted to quickly comment on what Mr. Vega was sharing with us. That, taking it from that perspective is quite important for us as privacy professionals. You really need to understand the essence, the significance of this profession in the first place, or the significance of, of privacy and data protection in the first place. Why is it important? You really need to, dig deep and really understand why we have laws in the first place, how technologies can be intrusive and how they can actually, and how, those laws, or why those laws, it's kind of the why, you understand, the why before the how. So you understanding why those laws are really important and why we have them to protect us, to protect individual citizens, to protect people, from being intruded upon, or from being, from their, privacy rights, from being violated or breached. So that is quite important. And I always, when I'm also talking with, or, advising companies generally, I always like to start from that angle as well. Especially if I'm training, if we are undergoing a particular training. So I always try to make them understand why this is important, why they need to comply with the law, because most companies will think it's just a tick the box exercise and that is all. But really understanding why this is important in the first place is really important. You understand? So we have lots of importance there. So we really need to use, so you really need to read on a lot of things, a lot of books that talks about the intrusive, how technologies can be intrusive, how technologies can actually be used to surveil us, to kind of pick on you and see what you're doing, some things that you might not want other people to know. So that is a very, very important approach, a very important perspective to kind of start from. So there are lots of books that I believe we can kind of recommend for you to read, and you can also read upon, and that's why it's also important for you to. I mean, it will help very well if you subscribe to different privacy resources. I mean, the resources that will send you information, news regarding different issues that's coming up from around the world. If it's the JIIPCC resource, or looking at different private, especially privacy technology companies, they always update you as regards different occurrences around the world, different violations from companies. So that's a very important thing to do, because this will also kind of update your knowledge, and it will really help you in terms of expertise as well. So so that's the why, which is quite important for you as a professional, and then for your clients that you're also going to be advising. And then the next stage is kind of the how, which is what we're going to be discussing today. So data collection, processing, and transfer. I'm going to call that. This is not all of the data lifecycle, but I believe what we're looking at today is we can summarize it to be the data lifecycle. You understand? Meaning that from the collection, because that's really what the data protection laws wants to protect. How data, how your information is going to be protected throughout the data lifecycle, from collection point to deletion. And so that's where we have data collection, processing, transfer, and then you might have deletion there, or even archiving. So I'm going to break it down into to make it easier, very easy for us. I think I'm going to break these things into 2 or 3 discussions. And that's going to be, talking about data protection principles, talking about the legal basis as, okay, I think we have best practices generally. So I'm going to be talking about the best practices as we talk about these things. Let me talk about the three categories I'm kind of dividing this discussion into first, which is data protection principles, lawful basis for processing personal data, and then a bit of transfer of personal data. So, and as I said initially, the data lifecycle actually cuts across all these things. So that's really what we're looking at. How do you, in terms of compliance with data protection regulation, how are companies collecting personal data? How are they processing it? So when you talk about processing, how actually that is the data lifecycle itself. But sometimes you might think that processing means the use of that personal data, but processing actually it's more expansive than that. So processing really it's the data lifecycle, so to say. So just for you to, because all these terms are also very important. These terms, just have that in your mind, that all the use of these terms are very, very important, no matter how small it is. Even if you're talking about personal data and sensitive personal data, they are quite important for you to understand this is what this means. And this can be used interchangeably, and this is the limitation for you to use these words interchangeably. Just like one of the questions that I saw that's referring to the differences between data sharing and data transfer. So it's quite important for us to know those differences, even if some of those terms can be used interchangeably. So I was talking about processing, and I was saying that when we're talking about data processing, we're really talking about the data lifecycle. And it's not only about when the company is using the personal data in its company. So, so when we're talking about the, so essentially, what I'm trying to say is that what data protection laws are there for is to really protect your personal data throughout this data lifecycle, throughout the processing, the data processing, procedure, so to say, or flow. So we're going to be talking about best practices as we're talking about the principles. We're going to be talking about, we'll start with the types of data and sensitivity level. Then, of course, the concept of data minimization is a core aspects of data protection principles, one of the core principles. Then we talk about, so that's the first thing we're talking about, aside the definition. Then we'll talk about the lawful basis for data processing. Then we'll talk a bit about data transfer. So when we're talking about types of data, you already know that, and it's the types of data that will also kind of tell you how sensitive a personal data is, So you already know that we have personal data, we have sensitive personal data, and you would have heard about special categories of data or personal data as well. So when we're talking about personal data, I believe you all already know what personal data is, which is any information that can identify an individual. So any information that can identify an individual, and that is also a core area for you to, that will always come up, because there are differences in that definition across borders as well, across jurisdictions. For personal data, essentially, that's what it is. It's any information like names, addresses, that's locations, phone numbers, email addresses, up to cookies, and other technology-related tracking that can identify an individual. So, and you also really need to understand what's the meaning of identification. We're talking about identify. What does this really mean? I think it's something you should look up for to really understand when a particular data set is going to be considered to be personal data that could lead to the violation of data protection laws by a company. So that's quite important. So we have personal data, then we have sensitive personal data. And the reason it is sensitive, it's still the same definition. It's just that it goes a bit further, which is there's more risk, that's the individual, the owner of the personal data might be open to, might be exposed to. So those personal information are more, they are more, I don't want to say sensitive again, they are more, and I don't want to say dangerous, but they are more risky, so to say, than all the personal data. So if such personal data, so in the sense of the definition, and then also when we're talking about the impacts of maybe enforcement from the impact and then the obligation as well. So when you have personal data and sensitive personal data, so the obligations that you have to protect those two different types of personal data differs. So you're going to have more obligation to protect sensitive personal data compared to when you have just personal data, and that is where the data classification will come in, and that is where I always try to talk about privacy engineering, which is a very important aspect of talking about how to manage all these things and how to really implement these things. Because when you have two data coming into, especially for a company that processes lots of personal data, large volume of personal data, when you have data, when you're collecting personal data, because that's also a technical concept sometimes, it could be difficult when you're collecting personal data. And so how do you differentiate them? How do you, since you have different obligations, to protect those personal data, how do you ensure that you are ensuring that you are fulfilling all those obligations or responsibilities regarding the different types of personal data you process? So that's why we need to talk about data classification in terms of, okay, what are the personal data we are collecting, and how can we classify them into different places that they're going to? I won't really bother you with that, but the reason I just wanted to, I'm trying to highlight that, to talk a bit about it, is because you will need to, for you to ensure that a company is abiding or complying with privacy regulations, you really need to ensure that the developers that's going to be building the systems or the applications that's going to be collecting personal data are really doing their work. So they might not understand all these things that we're talking about, but then how do you ensure that they know? So that's why we have privacy engineering. That's why we have that new area. I won't say it's not, I would say relatively new area of privacy engineering, where you have privacy engineers knowing a lot about privacy regulations and knowing about engineering techniques to implement data protection requirements in their systems as well. So it's something that's important for you to also look into. If you are really particular about a company, complying with privacy regulations or requirements. So going further, so that's personal data and sensitive personal data. So we have different examples of sensitive personal data as well, like racial, ethnic and racial information. We have religious background, and we have biometric information, and those things that are very sensitive, that could really lead to more harm. That's the impact of the impact of violating or of a data breach, of getting access, of unauthorized access to those type of data is going to be much more than if it is just personal data. So let's going forward. So one other thing that you need to learn as regards that, as I've mentioned already, is data classification, how to classify this personal data. It's something that is really necessary, that is very important when you are building a privacy program for a company. Privacy program means a comprehensive effort, a comprehensive project. Not a project, because privacy, as they always say, data protection compliance is a continuous project, is a continuous journey. So one of the things that you really need to do from the beginning is data classification, knowing all the personal data that the company processes and how to really inventory them, how to identify those personal data, and how to track them, so that you won't have the risk of shadow. There's a lot of risks, and I don't want to go into that, but one of it is shadow data, where you have a data and then you don't know that you have such data in your systems. So going further, I think we can start talking about data minimization now, or data protection principles, and data minimization is one of those principles. And I believe I spoke a bit about these in our last class. I went through all of the data protection principles, from lawfulness, transparency, and fairness to, that's just one, not three. So that's the first one. Then we have purpose limitation, we have data minimization, storage limitation, we have data accuracy. I'm not sure if I mentioned that particular one in the last class. Then we have confidentiality and integrity. Then the last one should be accountability. So, so I think I'll just touch on all these things briefly, since we've kind of spoken about it briefly the last time. So I'll see all the things that I can really add to these things. So lawfulness, transparency, and fairness, which is quite important, and which also goes to the root of ethics. So when you're talking about, because it's not only, you see that it's not just about lawfulness, it's not only as regards what the law has really required of the company to do to ensure that they are complying with data protection laws. So you really need to be ethical. A company needs to be ethical as well, which is the fairness aspect of data protection. So they need to be fair in terms of doing the right thing when they're processing personal data to ensure. So it's, I want to believe that it's one of the things that data protection authorities or regulator, like the Nigeria Data Protection Commission, ought to look at sometimes. You know, when they want to decide if a company has violated data protection provisions of law or not. And the reason this is, so meaning that it's not really, when you're looking at violation or enforcement mechanism, it's not really, it's not, they are not limited to just the, to just the law. I'll say that's my humble opinion though. So when we talk about lawfulness, it has, meaning that all of your processing of personal data has to align with data protection law. So it has to abide, it has to comply with those requirements in the Data Protection Act, the Nigeria Data Protection Act, as Nigerian, looking at Nigeria's case study. So then we have transparency as well, which is you having, so transparency has a lot to do with informing your customers of your data protection practices. And that's a very important best practice in terms of transparency. So, and one of the things you could also, because one of the things to also tell companies or clients is that to let them know that data protection is not just about compliance, legal compliance, the regulatory compliance, is that when you talk about transparency, it's really you kind of ensuring you gaining the trust of your customers and a kind of competitive advantage as well. So I think you can write those two things down. I mean, in terms of going outside legal compliance, those two, even if, because the thing is that if you don't comply, that's a what's it called? That's a violation of law. That's a breach of the law. So you might be subjected to, of course, enforcement, to fines, to penalties. But another thing that could kind of encourage a company to go further or to even embark on that journey of data protection compliance is those other advantages that could come out of you complying with data protection requirements, which is what I've said. Those two things. There are other things other advantages to it, but number one is customer trust. If you don't understand that, you can ask me. But what I mean by customer trust is, I always say that because you're offering your services, you're selling your products to customers, and the only way you can really interact with them is through their personal data. So the personal data it kind of represents those customers, and so the way you treat the personal data you handle, it's a reflection of the way you want to treat your customers, so to say. So transparency is you telling them that, oh, you're doing this, you're adopting all the kind of best practices to ensure that you are keeping their personal data safe, that you're keeping your customers safe. And the other one is competitive advantage. So when you're doing this and you have competitive in your industry, of course it's a kind of competitive advantage, like automatically, because customers will prefer such companies that kind of use their personal data in fairly in a legal and transparent manner than a company that does otherwise. So I mean, those two things can really up, even though they are not they might not be legally inclined, but they can also kind of up to to build privacy capabilities or initiatives in the company. So going further, so that's lawfulness, transparency. Then when we talk about fairness, as I've said, it's an ethical side, doing things right, doing things the right way. And even if, just like I say, I mean, using the CCP as an example, the California Consumer Protection Act. I mean, when we talk about consent, I believe we're still going to we'll get there when we're talking about legal basis for processing personal data. You will see that CCP actually, I mean, when we talk about consent, the obligation is actually opt-out, in the sense that you don't necessarily have to get, somehow, you don't necessarily have to get the consent of your customers before you process the data, but you must provide the means for them to opt out of processing their personal data. So if, as on the I don't want to go on the ethical ground there. The arguments I normally use is when you're a global company or you're operating across borders, and you want to, of course, you want your processing or your procedures or your programs to be kind of similar, to be the same, so to say. Then you have to kind of select a particular jurisdiction, a particular method in the jurisdiction to cut across all of your systems. Of course, you can do it separately as well, but then just to simplify things, you want to do that. Of course, what is going to be, because if you're doing opt-in, what I mean by opt-in is you always getting consent. Of course, most jurisdictions actually adopt that opt-in mechanism. So just like in Nigeria as well. So if you're using opt-in, I mean, it's better than, it's a way of telling your customers that you're ethical, that you're transparent about processing their personal data. So, but fairness generally, as I've said, actually has to do with you being, you doing things the right way, you being ethical about processing personal data in the company. So then the next data protection principle is purpose limitation, which is you not processing personal data beyond what you have stated. So that's still another, what's it called? Sorry, I lost my thoughts a bit. So when we talk about purpose limitation, we're talking about you not processing personal data beyond the reasons. That's okay. I wanted to say that's another kind of transparency, because when you're collecting personal data, especially in your, of course, you will have your privacy policy or notice on your website before you start collecting personal data. You will have said that, okay, these are what we're going to be using your personal data for. And for you to comply with, data protection laws, you need to abide with that. And sometimes you might think that all these things companies can go, of course, companies can, maybe they can find way around it by not complying with these things, because they are internal processes and they might not be known. But it's a very tricky game to play for many reasons. And so I don't want to go into that extra time, but it's until the regulator actually catches up with that kind of company before the game will be over for them. So, but when we're talking about purpose limitation, we're talking about you not processing personal data. If you say that the reason why you're collecting your data is to provide this service or these services to you, then you have to limit it to that. If you didn't initially say that you're going to be sending marketing communication, you can then send marketing communications or emails to that particular client. You have to, even though that's another issue entirely when we talk about consent, because you have to get consent for sending marketing emails to customers, so to say. Of course, there might be some limitations to that, especially when you're talking about, this is a tricky issue, but I want to keep it very simple. When we're talking about legitimate interest, when we get to lawful business, I think we're going to talk about that. And the reason you will find is that I'm kind of mixing all these things up sometimes. Like when I'm talking about a particular principle, then I jump to a different concepts. But I try as much as possible, not as much as possible, not to go deep into it. The reason I'm doing that sometimes is to kind of show you the connection between these things. So that's when we're talking about the other concepts, you might want to think about the other things that we've discussed initially. So it's sometimes helpful, but I just really hope that it's not very distracting. So so we're talking about purpose limitation. So that is really important. You need to ensure that, and that is one of the reasons you must have a data processing activity in place. Data processing activity is a kind of there's a name for it now, but the idea is that you must have a document that states all the activities, all the data processing activities that you have. That shows that, okay, these are the activities, these are the purposes we process personal data for, and these are the personal data that we use in kind of achieving that particular purpose, and ensuring that you've kind of informed your customers as regards those purposes. So data processing activity documents, as I said, there's a particular name for it, is really important. If anybody remembers, you can let us know. So that's purpose limitation, the second one, and then the third one will be, let's talk about data minimization. Then we'll talk about data accuracy. So when you talk about data limitation, data minimization, we're talking about, and before I go there, one of the best practice here is documentation. Documentation cannot be emphasized. It's really, really important. Everything you do in privacy, you need to document it, and that is a sign or a show of a demonstration of transparency as well. So because transparency in the sense that you're being transparent to the regulator, maybe during auditing or during a particular investigation, and this will really help highly tell people that when you have your documentation in place, you have everything, you're doing everything well, because we all know that in the cybersecurity terrain, when we're talking about data breaches, you will always hear the word that the statement that data breaches is not about if you're going to be breached, but it's about when you're going to be breached. In the sense that there's always a data breach will always occur somehow, so to say. So when you have all these things in place, that's when you can really minimize, and especially when we talk about privacy engineering, that's when you can really minimize the effects or the impact of the data breach on your systems, on your personal data that you own, which is part of your assets in your company. So when you have all this documentation and then you're being investigated, that even if you, number one, it could serve as a reason for you not to be fined in the first place. If you're doing everything right, you're ensuring that all the loopholes are covered, so to say, all the gaps are filled. So it will, to an extent, it might prevent you from being fined, from being penalized. And on the other hand, it can also reduce the penalty, the fines that the regulator might met on you, so to say. So so it's quite important. That documentation is quite important. That's why we have the data processing activity, that it needs to be documented. And when we talk about purpose limitation as well, it needs to be documented. And when we're talking about, so of course, as I said, it's a critical or a very important aspect of transparency. So talking about data minimization means that you don't collect more data than necessary, than needed. And this goes down to the roots of data privacy by design as well. So when we're talking about privacy by design, we're talking about considering the consideration of privacy from the start of a project, from the beginning of designing an application or even a feature. So you really need to at every point in time, you really need to understand or, consider the implication, the privacy implication of building that product, of collecting personal data from customers. So, and so of course, so if you're thinking about that, then it will let you know that, if you're deciding that these are the data sets we need from our customers, and so you'll have to think that, do we really need this data? If you're thinking that you might need you might want to implement a Google Map on your product, which will kind of track your customers. You might want to think that, do you really need that, or you just need just an address? So to say, a kind of a limited aspect, or a limited data points of that particular kind of data, of that particular personal data you need. So you really need to put all these things into considerations. So that's data minimization for you. So you really need to think, if you've already decided that you need this personal data, you might want to revisit it and say that, do we really need it? What do we really need it for? So all these things have to be documented. So data minimization is you not collecting personal data beyond what is needed, what is going to be used in the company. And then we have accuracy, which is talking about you collecting the data that is correct, that really defines the individual, so to say. Because there may be a lot of, especially when we're talking about AI now, data accuracy is quite important, because when you have false information about someone, there's a lot of harm that might actually come out of that. So it could be discrimination, it could be which is bias, you not getting what you ought to get, so to say. So data accuracy is very important. So you need to, and when we're talking about data accuracy and privacy as well, it also goes to the fact that you need to always ensure that the personal data that you have of an individual is correct, by always going back to them to check if they're still using that particular information, or they want to change it. So I have maybe I should quickly, because it's always important, it's always interesting to share stories as regards incidents happening in the space as well. So one experience I had recently as regards data accuracy was as regards the bank, the JIIPCC bank actually. And I didn't even know that particular number, a phone number, was linked with my account. And somebody that, how this thing also works, that's another issue that I think we also need to look at from a nation perspective, where in the telecommunication space, when you don't use a number again, then it's transferred to another person. So another person was using the number, and the person was able to buy data using that particular number on my bank account. So it was, I believe that's the last when that number, I haven't used that number for quite a while. I think when looking at when the incident happened, it was maybe like 5 or 7 years before the incident happened. I haven't been using that particular number, and somebody was still able to use not a number that I wasn't using again. So the best way the best way the bank would have prevented that from happening is probably in a year or two, to ask if a particular personal data is still linked to a service that they're providing. And another thing is, ordinarily they're even supposed to be tracking if a particular personal data, like that phone number, is still being used. And when you say that it's not, a customer hasn't used a particular information for quite a while, then it should have, the system should have triggered it. And that is where privacy engineering also comes into place, because there's no way, they have thousands, if not billions of customers. There's no way they would have, any of their privacy officers would, if they have, would have seen that. So it should have been programmed, and that might be as a result of a privacy officer informing the engineer about what they need to do. But if it's a private engineer that knows engineering techniques, that know that this is important, and this is a privacy requirement, then that gap would have actually been closed. So the essence of what I'm saying essentially is that in terms of accuracy, is that it's also possible for systems to be automated where where the system is triggered when a particular information has not been used for quite a while. So I know this is taking a while, but I just really want to explain all these things very well. And probably I might not go deep into lawful basis anymore, since we've also talked a bit about this in the last class. And probably if we have the time in the next class, I can talk about this. I'm not sure if we have other speakers around, so I don't take all the time. And then we can move to other things after I might have discussed all this. Hello, Dennis. Oh,
Yes,
I can
sir.
yes,
Yes,
sorry,
Mr. Kundara is on call.
I'm so sorry. So I'll be rounding up in a moment so that Mr. Kundara can have. Yep. So I think I've explained data accuracy. The next one should be storage limitation, which is quite important as regards. And storage limitation, when you're talking about storage limitation, we also talk about retention, personal data retention or data retention. And storage limitation has a lot of things to do beyond retention. So when we talk about retention, it means how long can you keep personal data for? The personal data of your customers, how long can you? So there needs to be, you must at every point in time for all your personal data that you have in your company, that's a company has, there must be a retention schedule. That's okay. This is how long, and that retention schedule can, of course, it might be kind of restricted, legally restricted in the sense that if a company is working in the financial space, as a financial institution, they might have that that obligation to keep personal data even when a customer is no more a customer of that bank, for a while before it's deleted. So such retention has to be, such limitations or such legal considerations or legal requirements will need to be considered when you're kind of perhaps working on a retention schedule. So that's quite important. But when we talk about storage limitation as well, it's also very technically inclined, because you might want to talk about archiving a particular data. We have, for cloud engineers, they really know about you transferring personal data from a particular storage system to another one, depending on the circumstances, depending on how a customer is using a particular service, maybe from a cold storage room to archive then before it's being deleted. But that retention or the storage limitation is quite important. And after talking about storage limitation, I believe if you remember, we've talked about lawfulness, transparency, and fairness. We've talked about purpose limitation. We've talked about data accuracy, data minimization, now storage limitation. So we have two more, which is confidentiality and integrity, and accountability. So when we talk about confidentiality and integrity, that's where cybersecurity or information security has a lot to do with privacy. And of course, there's a bit of difference between information security and cybersecurity. That's I'll leave that to you as an assignment. The difference between those two terms. So, but when we're talking about confidentiality, integrity, so it's part of the CIA triad. When we're talking about the three major concepts that makes up cybersecurity, confidential, integrity, and availability. So when you're talking about confidentiality, it means you not letting an unauthorized user or an unauthorized person having access to a particular system or particular data. And when we talk about integrity, this goes back a bit to data accuracy, where you want to ensure that the personal data that you're processing is accurate and is not being violated, so to say, so by external parties. So, and And a very to talk about to quickly talk about a best practice here is to talk about terms, which is not really best practice but a requirement. So terms are technical and organizational measures. So this is where, and when we talk about all of these principles, they are actually technical measures that you can really put in place to ensure that all these things are being implemented, because we're talking about the knowledge now. We have when you're operationalizing it in terms of implementing all of these requirements into your systems, especially for a technology company. So but when we talk about confidentiality and integrity, there's a lot of technical interplay here, because we're talking about a lot of IAM, which is identity and access management. We're talking about a lot of security measures or mechanisms that you can use to protect information, either from the network aspects or from the code aspects, which is because your code, the code that developers are also kind of working on developing, they really need to be secured as well. So it's one of the ways that security breach or privacy breaches or violations could actually happen. But many people don't really know that the software that developers are really writing could also be a means to privacy violations. So the last one, which is accountability, is quite important. It kind of encompasses all of these things as we're saying, and that is for a company to take initiatives regarding all of these principles that we've talked about. So what are the steps you're taking? Do you have a DPO? Are you ensuring that you have documentation in place? Are you ensuring third-party risk management in terms of when you're dealing with third-party providers, that ensures that you're providing specific services to your customers? Are you ensuring that they have all of these things in place as well? Are you ensuring that their systems are protected, they are complying with privacy regulations and all those things? So there's a lot of things that this also have to do in terms of documentation and implementation. So that's what accountability is, and that is quite important as well. Going back to why the regulator could reduce the penalty or the fines that they could have fined a particular company. So that's where I'll be stopping. And as I said, maybe at a later time I'll find time to talk about the lawful basis for data processing. And I believe Mr. Kedara will talk a lot about data transfer and sharing as well. So thank you very much for listening.
All right, thank you so much, Mr. Ridwan. We really do appreciate your time and the effort you put into just giving us a run through almost all the concepts and the sensitive level of data, minimization, lawful basis. Thank you so much, sir. We really do appreciate. So please, we'd like to have Mr. Solomon. Mr. Solomon, thank you so much for joining. We really appreciate your presence here. So, sir, I would like to give you just 20 minutes, if it's possible, for you to just give us a run through on the topic for today. You're welcome, sir.
Good evening.
Yes, good evening, sir.
Good evening, Mr. Kedara. Welcome, sir.
Yeah, thank you so much. Great to be here this evening. I mean, it's been some days. Would I say I've taken some days off? But then I'm really glad to be here, and it's indeed a privilege. So, yes, Mr. Ridwan took a very interesting approach in his analysis. I mean, it was quite analytical. I mean, his session was quite inspiring for me. I appreciate that. I enjoyed it. So, for me, this evening, I think we are looking at data collection, processing, transfer, of course, talking about the concept of data minimization, lawful basis, processing, lawful data transfer, international data transfer. So, well, maybe one of the things I would rather do is to virtually have us group the whole gamut of data collection, transfer, sharing, minimization, and all of them on that data processing, because all of them simply means data processing. So I think it may be quite confusing if we are discussing data processing and we're still discussing data collection and what is it called? Lawful data transfer, as if they are outside the spectrum of data processing. Yes, data processing is actually the broad spectrum, under which you have all kinds of activities in dealing with personal data, which includes data transfer, data sharing, collection, and all. So basically, I think I would rather take it from the fact that one, perhaps in so many instances, data processing begins with data collection. But then, in the real sense, that may not be exactly correct, particularly when it comes to when you are looking at data privacy from the concept of engineering itself. So, but then whether we look at it from the beginning as data collection, or we look at it that data collection is just one of the activities, of data processing. The fact is that data collection is part of data processing. And of course, data collection is actually quite clear. You look at the process where the data controller, is responsible for receiving personal data from the data subject. And of course, beyond that, the data is processed, is either stored, categorized, transferred, shared, and all of that. So for me, data processing here takes care of all the processing or activities of data processing. So then we move away from there. Yes, so we're talking about the types of data and sensitivity level. Again, when we're talking about, of course, I do not want to assume that when we're talking about data protection, our focus is personal data, not any kind of data, not financial data, not budgetary data. We're looking at data that personally identify, persons, individuals. And that's why when you are talking about some provisions of the law, of the NDPA, for example, it focuses on right and freedom of natural person. That's what some law says, while some other laws say right and freedom of data subject. So the focus here are personal data that individually identify, persons. So we are not looking at budgetary data, we're not looking at financial data, we're looking at personal data. And of course, just like Mr. Ridwan said, when you are looking at data here, you're talking about beyond that, the fact that you're looking at all data as personal data under the concept or regime of data protection, you get a category of personal data where some are categorized as sensitive data. Yes. One interesting thing is that we need to understand that in every jurisdiction, the law or the extant regulation, identifies personal data or categorizes them, based on their level of sensitivity. And that's why in some jurisdiction, a data may be seen as, or may be categorized as sensitive data, while in some other jurisdiction, the same data may not be seen or categorized as sensitive data. So when we are looking at sensitive data, we need to understand, we need to have recourse to the law. What does the law say? How does the law recognize this kind of data in Nigeria, in Europe, in America, and all? So that's also quite important. Then, of course, when we are talking about sensitive data, for example, you see some laws where health data, genetic data, biometric data are all recognized as sensitive data, whereas in some instances or in some jurisdictions, you have them rightly excluding some kinds of categories or classes of personal data. And that's why I said, when we want to look at it, which personal data, sensitive personal data, which one are not, then we must always have recourse to legal provisions, whether in a legislation or regulation. And of course, the concept of data minimization, maybe that is quite oftentimes relatable. Let me be quick to ask the question, which I've always had to ask over time. Particularly the mentees on the program. If you have actually had to open a bank account and your mother's maiden name was requested, your mother's maiden name, was requested, to be supplied as part of the information for the account opening, can I see you indicate? If you have attempted to open a bank account or you have opened a bank account, and while completing the form, there's a column, or a field where it is written mother's maiden name. If you express that, can I see your hand up, please? Oh, great. So Emmanuel Hugo says, yes, when I needed to have experienced that. Do I have any other person in the room? Okay. Yes. Okay. I actually would prefer essentially mentees. So quite frankly, it appears quite a number of us have actually experienced that situation. But then nothing to worry. Let me let you know why you have nothing to worry. I mean, nothing to worry because is it because there's no violation? No. It's because those who should know did not even know better. And that's actually the challenging part of the data protection regime in most jurisdictions. When you have people who should be the gatekeepers of data protection ecosystem, not know as much as you do. If I dare open can of worms, when it comes to data protection ecosystem, particularly the gatekeepers, many of us will be shocked that we have to have a rethink whether we're actually serious about data protection in our country. But then maybe we are doing better than some other, some other ecosystem or some other jurisdiction. But let me honestly ask Emmanuel, when you were asked the question, your mother's maiden name, how did you feel? Did you think it was required? Do you think it was necessary? Or do you think it was actually not connected in any way to their account opening? Can I have your response?
Actually, so I was wondering what relationship my mother's maiden name would have with the creation of my accounts, but I didn't voice it out at the time.
Perhaps they were trying to see so that when you do anything unlawful with your account, they can trace your mom or your mom's dad to identify you. In your mind, maybe you will be thinking that way. But then there were so many things we have been made to do that didn't make sense. And guess what? Even those who required us to do those things, it didn't make sense to them. They just realized that they were doing it and nobody bothered to question. But then the whole concept of data minimization is the fact that, you are required only to, process personal data that are directly connected to the purpose of processing. Now, let me use this concept. You see, anytime I'm actually have this kind of conversation when it comes to knowledge sharing, I am not given to just sounding fanciful. I would rather want us to have the gist, understand. Many of us have issues of violations of personal data around us on a daily basis, but we don't get bothered because it has become a norm. It has become a tradition. Like I always love to give examples. When sometimes you sit down in the comfort of your room and somebody, a message pops up on your phone. Hi, Emmanuel, we just opened a new pizza shop nearby you. Please come around and have a taste of catfish flavor. For God's sake, Emmanuel, the last time you entered the shop and purchased any pack of pizza, did they tell you they were going to send you an SMS for marketing purpose? No. They only demanded for your phone number for the purpose of placing the order. Did somebody get the point? Hello? Hello?
Yes, sir, I get the point. I get the point,
Can
sir.
you hear me?
Yes, sir.
Now,
Yes,
Yes,
sir.
sir.
I realize that on daily basis, our personal data gets violated. And we are not having conversation around it. Why? Because sometimes we don't even know these are clear cases of violation. Maybe some persons are actually getting more realistic with the circumstances. Now that people know that you can't just sit down in your office, and because you have a target to hit a number of accounts, in a year or in a calendar, the next thing is that you start opening new bank account for your existing customers. Such conduct will push you to violate customers' personal data. And that's actually a contravention of all extant regulation and legislation. So my point here is that the issue of data minimization is to prevent data controller from just packing and gathering all kind of personal data. There's this proverb in Yoruba. I'm sorry, so I'll first say it in Yoruba, and then I will translate it, to English. It is said that eyada ohwada lonjekeru wiripo, meaning being interested in packing all sort of items, it's actually the recipe for madness. When a madman, you see, all of us, when you walk on the street and you see a full-blown, lunatic, mad person, you wonder why how that chap has actually gathered so much. But then, you see, the reason why he was gathering them was because he was thinking every piece of item picked up around him will be useful someday, even when they will never be remotely useful in the next 10 lives. Do you get the gist? And that's what happens with data controllers around us. They just pack all sort of personal data that they may never need. One of such instances, anyone in the room who actually could have gotten what is it called, their NIN maybe 10 years ago, and you got enrolled at one of NIMSI centers, you will realize that you completed a 60 field form of about I think 5 or 6 pages, wherein some questions like your religion, your bank account, your bank card, your mother's maiden name, information that they can never use, information that are sensitive. Now, but today, if you have actually been enrolled within the last 1 year, I can categorically tell you that the form you completed was actually a 10-field form. Because I was privileged to have advised some development partners who advanced, they had an agreement to advance a credit of $430 million to Nigerian government. And one of the recommendations my team made was the fact that, look, you could not actually run this project without violating people's rights when you are using a 60-field form to collect personal data. Most of the fields, the information on most of these fields are not in any way remotely related to the whole concept of digital identity. And of course, it was quite interesting because they agreed and reduced, imagine they took away 50 fields, imagine. So that's actually representative of how data minimization should not be complied in our society. So let me move away from that and touch briefly on of course, lawful basis for data processing. Now, what I will try to do is, okay, so there's some questions I saw, and I think I would rather want to leave very robust insight to the question answering, because for me, I think using case studies, using live examples, using decided authorities, actually fleshing up our insights and understanding of issues. So let me stop at this point, and of course, I will be able to, robustly respond when we have to answer questions and all. Thank you.
Thank you so much, Mr. Solomon. We really do appreciate your time spent in just trying to give us a highlight and an explanation into the various aspects of the differences between personal data, sensitive data, the processes around data collection, and just the overview you gave. So we really thank you so much, sir, for that. All right, so please, we'll be having our group presenters, right? Group 1 and Group 2. Please, you have 7 minutes for your presentation each. Can we have the group presenter for Group 1 make presentation on behalf of the group? Then we'll take presentation from Group 2, 7 minutes also. Then our mentors will come and give us a little feedback. So can we have Group 1 presenter?
Hello, good evening.
Yes, good evening. Good evening, Fatia.
Yes, I'm the presenter for Group 1, and I'm trying to. Okay, thank you. So the topic for discussion is data collection, processing, and transfer, and the concepts of data minimization. So in my own little understanding, I would say data is like a raw fact. So with what we are experiencing in the technology world, there have been like an increase in the rate at which data has been breached. So that's why countries have enacted their regulations to protect data. So some concepts about data regulations are the data collection, data processing, and transfer. So data collection has to do with gathering of data. That's like it can be done manually or digitally. So manually is like the normal processes like your document, gathering of documents and all. Why the digital has to do with you filling survey online, just has to do with using the internet. That's like the digital. That's direct collection, indirect collection, and automated direct collection. So direct collection is like you're getting from the source, the real source. So that's like filling out questionnaires, surveys, Google Forms, and all. So indirect collection is like from a third party, you are hearing from another party. So that's another way of collecting data. And then the last one is automated collection. So that's just from the internet. So the likes of cookies, maps, tracking, and all. So then we have types of data and their sensitivity level. Just like Mr. Adrian Badman said, we have the like of personal data, which can be sensitive and just be identifiable data. And then companies will have their own kind of data that's the sensitive institutional information, and lastly, the demographically identifiable information. And there's for this, some of the definitions are included in Section 65 of the Nigerian Data Protection Act. So they are sensitive data, like some of them are high, like the sensitive personal data and the sensitive institutional information. But like the personal identifiable information and demographically identifiable information is, the sensitivity level is from moderate to high, is not high risk like the sensitive personal information. So the best practice for data collection is that we should ensure transparency. So that's like the concept of data processing in Section 24 of the Nigeria Data Protection Act. So auditing too, we should comply with the local legislation about data protection. So we should ensure that consent is being taken. Consent should not be taken under duress or fraud. So it should be legal. So next is data processing. So I think I'll use an example of a computer where we have the input, processing, and output parts, so the IPO. So the data collection is like the input, and then the processing, that's data processing. So this is where you process your data for use. So the level basis for it, you can find that in section 24 of the NDPA. So that's like consent. You must get the consent of the person, of the data subject. So data minimization is like what you've gotten the data for, you must use it for, just like purpose limitation too. And then data integrity and confidentiality. The data subject must have confidence in you that yes, you are using data for that end. Then accountability and transparency, you must be accountable to the data subject. Next is the best practice for data processing. So you must ensure security. So security can be like encryption, authentication. Then you must implement data processing from the design, from the onset. So like data privacy from the onset. You must make sure that you've included the data privacy in your design from the beginning, so that it will reduce the risk of data breach. And then employee training, train your employees, because never can know when data breach will happen. So another one is data transfer. So I think this data transfer will be like the output part of the computer. So that's the sharing your data to a third party. So it can be internal, external, or cross-border. So internal is within an organization, external is outside an organization. Why cross-border has to do with another country? So it depends on the agreement between the countries. So the best practice for securing data transfer is the security part, that's the encryption or authentication. All these into, we must comply with the legislation of the country, and then data transfer agreements, like you must abide by the agreements between the countries or companies. So we have data minimization, that's the last part. And the limiting data intervals, so the principle of limiting data collection and retention, so the bare minimum possible. So the benefit is that it will reduce the risk of data breach. Then the data subject will have trust and the company. Lastly, it will reduce the penalties or avoid the companies paying fines if they don't comply with the legislations. So the key features, just like the features of data processing, that's like limited data collection, data accuracy, transparency, lawfulness, fairness. Then implementing strategies, like they should invest resources in privacy, enhancing technologies. They should educate their staffs too about the risk. And then they should develop strategies for data retention. So challenges in implementing data minimization is that you have to define what necessity means, because it can be complex. Also, the organization needs and business operations have to be balanced. So that's an issue. Then data governance is another challenge in implementing data minimization. So our questions go thus, therefore. So 1, is there a discipline or law for data sales to a third party without the consent of the data owner? 2, can an individual sustain a private action for the above? 3, what kind of agreement should be used for a data transfer? 4, what is the difference between data sharing and data transfer? So this is our presentation for group 1. Thank you very much to the speakers.
All right, thank you so much, Fatia, for your presentation, and well done to your group for putting together a presentation. I'm sure we'll be hearing feedbacks from our mentors very soon. So while we kindly wait for that, group 2, can you kindly come up and make your presentation so that we can move on with the rest of the class?
Oh, a long one.
Hi. Good evening, speakers.
Yes. Good evening. Can you hear us?
Yes, I can. Can you hear me?
Yes. All right. So please, you can kindly go ahead and share your screen.
Yes, please. I want to attend my healthy also.
So you said?
Can we also my screen now?
Yes, we can see your screen. Your voice seems to be shaky.
Can we hear me now?
Yes, we can hear you now. Hello, Tommy, are you with us?
Can you hear me?
Yes, we can hear you better now.
Okay. So good evening, everyone. My name is Tomi Fakos, and I'm going to be making this presentation in representation of Group 2. So for the topic given to us, which is stating that we should talk on the lawful basis for data processing, lawful data transfer, international data transfer, and inciting cases and example. So here we have the table of contents on exactly what we worked on. So for legal basis for data processing, like Mr. Ridwan has rightly said, is data lifecycle. That means the states where a data begins and where it ends. So the reason for which an organization or a company is receiving a data, the purpose they want to use it for, and it also extends most times to the storage and disposal of that particular data. So that is what data processing implies. Now, this data processing also have some legal basis, which can be seen in section 25 sub 1, like is rightly stated on this slide, where it's also stated that the data processing is expected to be lawful and should be taken with consent. So moving on to the next slide, we have the legal basis exactly highlighted in the Constitution for data processing. So before any organization can actually use a data, or before a data can be processed, that means from the storage to transfer and all of that, a consent is required. There's a need for contractual agreement as well. That's performance of a contract. Processing is also necessary for compliance with legal obligation, and processing is necessary to protect vital interests of data subjects. Processing is also necessary for performance of a task carried out in public interest. So it is necessary that before any data can be processed by any organization, all of this required under the NDPR, as well as simultaneously required under the GDPR, is supposed to be followed before this data can be said to be having processed rightly. We also mentioned some case studies on data processing, and I'm just going to briefly state what these two cases is talking about, because they handled simultaneously the same issue, and that's the issue of NIN, where the court held that whenever they are trying to disburse the NIN, that is the national identity numbers, there is a need for transparency and accountability in data processing. So this is also the decision in the other case. That's the second case that we have on this slide. The decisions in this case are quite just emphasizing the importance of data protection and privacy, which is also prioritizing the citizens' personal data. So with this, I move on to the review under the lawful data transfer. That means what makes the transfer of a data lawful, either domestically or internationally. So by domestically, I mean within Nigeria. So these things are actually already provisions that have been made by the law before a data can actually be transferred from within Nigeria and from Nigeria to outside Nigeria. So for the provisions as the review of lawful data under the NDPR and GDPR with illustrations, we just have that for under the NDPR, they also are stating the same thing, emphasis on data minimization and the purpose limitation. So all of these things, as been rightly said by Mr. Ridwan as well as Mr. Okedara, when he was talking about the fact that data is meant to be collected not beyond the reason that it's supposed to be used for. So when a data is required for a particular purpose, the data that should be collected should be restricted within that purpose and not requiring a data that is more than the purpose it is supposed to be used for. Now we move to, I forgot to mention on this part, the emphasis on transparency and accountability. That means for organizations to be able to transfer data within Nigeria, according to the provision in section 25 sub 2, the data is supposed to have been, the consent is supposed to have been given by the data subject And whatever it is that will be using that data for, that means the contractual agreement, it must be complying with the NETDA regulations, which is also very crucial. So for international data transfer, that means review of data between Nigeria and other countries, it is required by the law. Like majorly, there are 4 things that are required. The first thing is the adequacy. And what this adequacy simply talks about is the fact that whatever country that these data are being transferred to, that country must have in place adequate data protection laws. That means if it's being transferred, let's say from Nigeria to Ghana, Ghana must have had adequate data protection laws that can also cater or be in the same light as they can care for the data the same way Nigeria cares for data. Like they must be on the same level when it comes to data protection. And the second relevant part of this is what are the conditions for this transfer? This has also been rightly stated according to the law, states that this particular data should also be based on adequate data protection, like I've said, and it must be for vital interest. Yeah, it must be for vital interest of the data subject, and the data subject must have been given consent. So this principle of consent is something that I think is very outstanding when it comes to data transfer. So whether it is going to be going within Nigeria or outside Nigeria, the data subjects are always supposed to have been consented. That means contextual reasons are like very, very vital when it comes to data transfer. And the third major thing that is just essential to this cross-border transfer is the mechanism for transfer. How are these data transferred? This is also something that the law has covered, stating that this data should be transferred by standard contractual clauses. That means whatever contract that, or performance of contract that will be given, it must have been standard enough. Whatever reasons or basis for that particular data transfer must have been standard. And we have that the binding corporate rules as well, which is known as the BCRs. We also have the certification mechanism. So that's like the third major part of international data transfer. And the very last one is the supervision, which is also mentioned here, is that this data transfer must be supervised by the Attorney General of the Federation. That means the Attorney General of the Federation of Nigeria is actually responsible for supervising data transfer outside of Nigeria. Okay, so after we looked at this, we just went on to incite some case study and illustration. And just to briefly explain what this is saying, in the case study, that is in the case of Digital Rights Lawyers Initiative versus National Identity Management Commission, this case is a Nigerian tech company that transfers user data to a third-party analytics partner in Europe without explicit consent. That means the fact in this case was that data was transferred without explicit consent, and it made the court emphasize on the need for explicit consent. Like I've said before, it's like it's very prerequisite when it comes to transferring data, like very, very prerequisite. So in this case, the court emphasized the need for explicit consent and adherence to GDPR provisions. That's when it comes to the data minimization, when it comes to the purpose of limitation and the likes. And based on the illustration we gave, this illustration is saying that a Nigerian service company uses cloud transfer and uses cloud storage to transfer data to the US without complying with NDPR provisions. So the NDPC issues a fine against a multinational company for abusive and invasive practices, including unauthorized data transfer and exploitive privacy policy. So this illustration is just saying that a data went out without complying with the NDPR provision. Like I said, when it comes to the issue of data transfers, all of this has been, to my understanding, have been well covered according to the law, and these procedures are expected to be followed. So moving on to maybe some challenges and future developments for enforcing data transfer, I think we majorly talked on the awareness and compliance. So it is important because awareness is very key. Most times what people are not aware of, they intend to misuse or abuse. So awareness and compliance is very, very important. We also highlighted the usefulness of regulatory capacity. We also talked on involving legislations and the likes when it comes to ways to actually improve data protection implementation in Nigeria. And looking at some monetary fines, we can see that for every penalty or for every data breach or for most issues that are overwhelming when it comes to data protection and privacy, there are well-alighted penalties for those things. There are reputational damage, there are legal action. You can see that 2% of an annual gross revenue or 10 million naira, whichever is greater for serious breaches, and 1% or 2 million naira for less several breaches. So it is to state that there are penalties and enforcement in place, and despite all of this, there are still little challenges. And what we have done is trying to highlight the way these things can be overcome and the way the challenges can be well managed and minimized. So in conclusion, the team has been able to, or rather Group 2 has been able to understand better the processes it takes for transfer domestically and internationally, and to also state the challenges that are faced for upholding these particular standards that are in place for lawful data processing. And the questions that we had were just 3. And the first question is, which court in Nigeria has jurisdiction over data-related issues? And the second question is, which court has jurisdiction over international data transfer breaches? And the very final question is, how does NDPR addresses processing of data for purposes beyond the original intent? So these are the questions, and thank you very much for listening. Thank you to the speakers. Thank you to the moderator. It's really been a wonderful class. Thank you, everyone.
Thank you so much, Tommy, for that presentation. Well done to you and your group for putting that presentation together. All right, so before we have our mentors' feedback on the presentation, can we kindly turn on our videos for those that have lighting in their background so that we take a quick picture? My own background is a little bit it's quite dark already, right? So that we can just take it for posterity's sake. So please, those who have a little lighting in their background, please kindly turn on your video so that we can take a quick screenshots. All right, can we have mentees turn on their videos? Thank you so much, Deborah. Thank you, Obafemi. Thank you, Precious. Thank you, Ifeoluwa. All right, please, can we have more people? Thank you, Eno. Thank you, Emmanuel. Thank you, Margaret. All right, we're done with that. So over back to our mentors. We would like to just get a little feedback from them as regards the presentation, and maybe any further knowledge they would like to add in terms of the topic for today. So over firstly to Mr. Ridwan. Mr. Ridwan, please, we would like to hear your thoughts on the two presentation, and if there's any other added information you would like to share with the class.
Yeah, thank you for that. Yeah, thank you to Mr. Okedara as well. I mean, I really learned a lot of things from what he said from his presentation earlier, before the presentations from the participants, the mentees. And I wanted to even ask if it was the same theme that's presented in the last class, or it's they are different, because this presentation was far better than the previous one. And so kudos to the to the improvement that you've made. So it's quite interesting, and it's also gave me kind of assurance, and I'm also quite confident that you understand the lawful business, because I noticed you explaining what the lawful business are. So I don't think I really need to cover that again. What you just need to do is just to review or to read further on that. So aside that, I don't think I have any other comments to make. Thank you very much. Well done once again to both teams.
All right, thank you, Mr. Ridwan. We really do appreciate your comments and your feedback. So please, can we have feedback from Mr. Okedara before we go to the question and answer segments? Mr. Solomon, are you still with us, sir? Okay, it seems Mr. Solomon is no longer with us on the call. All right, so Group 1 and Group 2 sent in some questions as regards the presentation that they made, and I will just be going straight to just post the questions on the group so that Mr. Ridwan can just help us run through the questions and help us answer them. So for group 1. Okay, I think this is for group 2. The questions here is there a discipline law/law for data sales to a third party without the consent of the data owner?
Okay, because I'm going to be leaving soon, and I think I'm the only mentor left, so I'm going to be answering this because it's almost time for my prayer. So I will be very brief with the questions because I know we have lots of them. I think 7 in total, if I'm not wrong. 4 from 2 and 3 from the other group. So the first question as regards if there is a discipline or law for data sales to a third party without the consent of the data owner. Of course, I mean, that's what the discipline or the law for that is the data protection laws that we have. So there's no specific or a different, legal framework or regulation for that particularly, talking about different jurisdictions, we have specific guidelines talking about the sales of personal data. But of course, the general rule for all in all data protection laws is actually that you need the consent of data subjects before you can transfer personal data to a third party. But of course, it's if when a company, data controller or a data controller, of course, has given information, has informed the data subjects that in order to provide them the services that they have contracted with the data controller, that they will have to, of course, maybe contract with another third party, a data processor, or even if ordinarily to provide that services, they will have to, partner another company and then probably share that personal data with them. Then that will be allowed. I mean, that is permissible under the law since it's still covered under the lawful basis for data processing. So in essence, to answer the question directly, is that the discipline of the law for data sales, of course, the thing is that, okay, I think I also need to mention that, I mean, because data sales is kind of highlighted. So when we talk about data sales, you're not ordinarily allowed. Maybe I should answer that separately, if in case that's the intention of the questioner. Data sales is actually not allowed except where consent has been given, by the data subjects, and this is even dicey because even if, I mean, we're talking about data sales here, even if data sales, it's kind of, as I said earlier, it's dicey because even if the data subject is giving you the consent to sell their personal data, so there could be some other issues that might come up. I just want you to think about that as well. Generally, issues like if it is between an employee and employer. So in terms of the authority, there's a particular term for this, but in terms of the authority that the employer has over the employee, and some other issues like that. But of course, if you look at the CCPA again, the California Consumer Protection Act, which says that data controller, I mean, in that regard, because I think there's another name for them, I can't really remember now. I mean, in that jurisdiction, they have to give information, they have to inform, data subjects if they are selling, personal data. That gives a kind of idea that data sales, in that jurisdiction is actually allowed. But in other jurisdictions, like maybe in the EU or Nigeria, it is, I mean, you can only, the only thing I can say is that you can only sell personal data, data of your customers, if they give consent. But if without giving consent, you can't do anything. And so generally, as we've already known that any kind of interactions with data, any processing of data has to be in line with provisions of law, provisions of the data subject, the Data Protection Act. So meaning that they still have to abide with the legal, the lawful basis for processing personal data. So one of them is the consent that we've mentioned. So, and that is the only way that data can actually be transferred or even sold under the law. So consent has to be given, but then you need to look at the opt-in and opt-out issue with, as well, especially the opt-out issue in California. That's under the CCPA. That it will be an interesting thing to kind of read on. So that's my answer on that. So if I may go to can I go to the second question?
Yes, sir, you can.
Okay, thank you. Okay, I saw another question before I go to the second question. In terms of books, resources for further reading, I mean, there's a lot. There's lots. I think because of this, I might have to, I'll try to probably compile a resource for this so that, I mean, you can reach out. Maybe I'll share it with the organizers, or you can always, of course, anyone can always reach out to the LinkedIn, and we can have further conversations and share this as well. So in terms of can individuals sustain a private action, of course, for any privacy violation, I think most jurisdictions, I know Nigeria, EU, most jurisdictions actually give the rights of the right to claim, or right to enforce, the right to sue to individuals as well, data subjects. So of course, individuals have the right to private action against the data controller if they sell their. So this is aside the obligation or the duties of the Data Protection Authority or the Nigeria Data Protection Commission in the case of Nigeria to also fine, because that's, I mean, if you're selling without the consent of the data subject, that's a violation of privacy requirements or data protection laws, and if that is of course the data protection authority or regulator will of course most likely penalize that data controller for that. So then regarding the third one, that's what kind of agreement should be used for a data transfer. So this is actually the plans, and we also have a question regarding I think that's the fourth question. What is the difference between data sharing and data transfer? So I'll just take this together. So, and I'm not sure, it seems I thought we had a question regarding, or maybe it's this question, maybe I was just thinking something else. So what kind of agreement should be used for a data transfer? We have different types of agreement or types of mechanisms for data transfer generally. So I'm going to pick out I know all of you will already know about data processing agreements, and that's generally when you are sharing personal data with a third party to provide services to your customers. So that's a data processing activity. But that's what if you are the service provider is not within your jurisdiction, is outside jurisdiction, maybe using the UK or US, like Microsoft's. We're talking about maybe, let's say Google Drive. You're using Google Drive, or you're using, that was also data sharing as well, actually. Or let's use something that is practical, or that is active, in the sense that maybe you have another partner that's asked to process that personal data for you to be able to provide services to your customers. Then in that regard, of course, there needs to be data processing agreement. So what I'm trying to say in essence is that it's also one way of ensuring that data processing across borders, which can also be called data transfer, so to say, can be what's it called? Can be guided or can be regulated by that data processing agreement. But we have mechanisms that are provided by law itself, in terms of which one of the groups actually went through when we talk about binding corporate rules. I mean, it depends on if you're processing personal, if you're sharing personal data with a sister company. I mean, if it's a multinational company and then you're sharing data, it's still within the company, but then it's outside. It's outside the jurisdiction. It's outside the jurisdiction of the company that is sharing personal data. So there's binding corporate rules, and if we have, especially in the EU, we have something called I think we have data transfer agreements. We have different templates. It's just like SCCs. SCCs are standard contractual clauses. So all those agreements, all together, data processing agreements, SCCs, and all those things, they are actually in place to regulate the transfer of data or the sharing of data. And that's the reason I'm using data sharing, data transfer and data sharing together, because they can be used interchangeably at sometimes, but the meaning could also differ sometimes. So data sharing is, I mean, in my opinion, is more broad, is broader compared to data transfer. So when you say data sharing, it could mean you sharing data with third parties or even within the company. Or you're saying data transfer, even in the technical sense, it's like you moving data from one place to the other, not really sharing, not really ensuring that you want to process that personal data. It's just like, when we're talking about the data sales, so you're transferring from one party to the other. So you can look deeply into this, but most times, I think when you're discussing data protection issues, pros tend to use these words or these terms interchangeably. So you really need to watch out for that. But I think it is safe to use it. But then, of course, data transfer is mostly used when we're talking about you transferring personal data across borders. But when it is within borders, when I mean borders, I mean within Nigeria and not to another country or clime where we have another data protection authority, then that can be called data sharing within the company. So I hope that is clear, but I would really encourage you to do more research on that. So I have very little time. So the other question, I'll go to Bron's question now. Okay, sorry, it's the same question. Can I have the other questions from group 2? Or was it group 1? That was the last group that's presented.
Yes, sir. That is group 2. So, sir, the questions the questions are on their presentation, so I'll just be reading them out to you straight out.
That's
all right. So the first question is: which court in Nigeria has jurisdiction over data-related issues? Which court in Nigeria has jurisdiction over data-related issues?
Okay, great. Mr. Okeda is back, so I think I'll just hand over the rest of the questions. Mr. Okeda. So Mr. Okeda will answer those sort of questions. And I was even thinking initially that he's even in the best place to answer this particular question, because according to the arts, it says any courts, but Mr. Okeda has really worked in this space quite a lot. So I will also take Mr. Okeda's. I would like to leave now, sir, if you may permit me.
All right. Thank you so much, sir, for your time. We sincerely do appreciate your insight and your knowledge into the topic that you have shared with us. We'll just be running over the question or the rest of the question. Okay, before we go to that, bye-bye, sir. So before we go to that, I would just like to confirm from Mr. Solomon if he was able to hear through the presentation that was made by Group 1 and Group 2, so that we can get maybe a little feedback from him.
Hello,
Mr. Solomon. Hello, sir. Are you still with us? Mr. Solomon. Okay. It seems Mr. Solomon is okay. Mr. Solomon, are you back with us, sir?
Hello? Hello?
Yeah. Yes, sir. We can hear you, sir.
Hold on. Yeah, firstly, let me apologize. I'm actually in a location with limited access to internet connection. So it's been on and off. So I'm in a resource center. So yes, I'm back. And what have I missed? And what am I getting on?
Oh, all right, sir. So I I was asking if you had the presentation made by Group 1 and Group 2, if you could maybe give a little feedback to it, sir.
Oh, yes, I did. I followed some of them. Yeah, the first thing is, let me first commend Group 2. They actually had a very, I think, a fascinating presentation. I mean, their slides are clearer, the color blend, the character, and of course, even the content loading, particularly as to there'll be something I've been commenting on for quite a number of cohorts, and I'm not talking about for 2024, maybe 2022, 2023. And that has been, if you are professionals or budding professionals, you better pass across your understanding of knowledge with examples. In this case, if you are a law student or a young lawyer, you should be able to give us decided authorities. What has the court said, either in Nigeria or in state jurisdictions. So, but this presentation slides, I can see, cases. And sometimes I even wonder that personally, some of these cases I even look forward to see, I have been involved with them. Most of them, maybe out of 10, maybe 8 of 10, you will want to cite, I was involved with them one way or the other. So now I keep wondering, why can't these, younger friends lay their hands on these cases? And most of these are online. You can easily find them. So can I ask for the presenter for one? Presenter for one, are you still in the room? Okay, anybody in from group 1, can I see your hand up? Group 1. Okay, okay. Fatia, can you hear me?
Yes, I can hear you, sir.
Which group are you?
Group 1, sir.
How many cases guys cite in your presentation?
Close to 4 for each data concept, but I did not mention it.
You don't mention it. You mean you did not mention it? I went through your slides and I'm not sure. I mean, I may be mistaken. I didn't. My hands could not even, stop any case name. I'm saying that because if you are familiar with a particular subject and you know of cases around it, you could not see cases. You'll be wondering. So let me give you an example. You or whatever reason are writing on Crime Act in Nigeria, and you are this former section 24 of the Cyber 2015, not the newly amended one, and you want to have a broad expose on it, and you are not citing Solomon Kidera and general definition, you honestly will think you didn't start to have an expansive discourse, because if you did, then you know that in such a case you most likely will have to touch on, because is that that broadly looked into it. So that's what I'm saying. That I'm not sure. Even group 2 that I saw some of the cases, they also could have done better. But maybe for yet another time. Please, when you are looking attentive, and it's for people with the knowledge of law, whether as law students or lawyers, please, one of the first things you need to do is, what are the decided authorities? In what the court decided on people? And look up for them. In Nigeria, let me tell you something. I when it comes to an area I get interested in part-time, and maybe that said that these are the number of cases decided on this subject in the whole wide world. I could remember that I was arguing a case before my Lord Justice Lehman of the Federal High Court. And my Lord said, Mr. Kedara, are you saying there's no country, no other country where we have such law? I said, my Lord, I work on this every day of my life for the past 6 years. And I can tell my Lord categorically, there's no country with such a provision like this. The only once had such is United States. And I cited it because it went as far as Supreme Court. So as professionals or body professionals, you are a custodian of knowledge. And at each time, we should be able to trust your knowledge of that. I'm not asking you to be to have knowledge of all situations part time. No, I'm not asking you to do the impossible. But please, as much as possible, challenge us. Even those of us who have led to give us expand as an so please presentations for subsequent classes or sessions. Fetia.
Sir.
Do I have a promise from you to do me the honor of subsequent sessions?
Yes, I promise.
Thank you for that. And thank you.
All right,
I think
sir.
I would. Yes.
Okay, sir. Your network seems to be ceasing. We are not hearing you fully. Some
Oh
parts
my
is
goodness.
out.
Can you hear me now?
Yes, sir. We can hear you better now.
Okay, but then I guess Fetia heard me because make I
Yes, sir.
I was only kidding, but I just made that to excellence, which I think good thing I should do.
Thank you so much, sir. So,
Let me move.
Sir, can you hear us, sir?
Yes, I can hear. I can hear you.
All right. So please, I want to confirm from the mentees first. Is it only me having issues hearing Mr. Solomon, or is it a general problem?
My goodness, but I can hear you clearly.
All right. It seems you're.
Sorry?
Yes, sir. I say it seems it's better now.
Oh, please, can you stop the that should be able to? Fetia, can you hear me?
Yes, I can hear you.
Dennis, can you hear me?
I can hear you now, sir.
If you can hear me, say yeah. Yeah. So nobody's hearing me though. I can't say yeah.
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 Aha. I'm just I don't. We are not in a comedy stand-up comedy show. Question. Yes, it's breaking intermittently. I'm sorry. I told you I have access to, limited internet connection. I'm sorry about that. So can I take the
All right, sir. So the
question?
first question here we have is which courts in Nigeria has jurisdiction over data related issues? Which courts in Nigeria has jurisdiction over data related issues?
Okay, so I would have actually loved to dynamic in my responding to the questions, but like engaging mentees and all of that, because trust me, oftentimes when we ask the questions, we know the answers. We're not just too sure. So, well, Section 65 of the Nigeria Data Protection Act 2023 says it is any court that is any court of competent jurisdiction as jurisdiction. But maybe I would not have to ask the questions. What does that mean? Which court will be qualified? Which court is the law talking about? Fatia, do you have an idea? Fatia. Okay, don't worry. I think I'm thinking of Fatia. I will call so many other persons. You are sitting down there. You think you are using juju so that I will not see you. I will see you and I will call you. Emmanuel.
Yes, sir.
Yes, your juju did not work. I caught you. Okay, so Emmanuel, so the Section 55 says any court of competent jurisdiction will be the court that has jurisdiction on issues under the Act. Which court would that mean?
That would be the Supreme Court, sir.
Emmanuel, Supreme Court. Oh, Chairman.
Good evening. According to section Article 48, Section 2 of the NDPA Guide, it says that anyone who wants any data subject who wants to seek redress for the violation of his or her right to privacy may go to the closest state high court or federal high court for redress and for damages to their rights.
What provision? What law did you cite? Article what?
The Article 48 of the Nigerian Data Protection General Application and Implementation Directive of 2024.
Okay. So it may go to
the state high court or the federal high court for redress.
Okay. So how do you marry that with the provision of Section 65?
Well, I would say that, okay, for the guide was brought out to bring an implementation to the NDPA. So there is a provision in the guide that says that where there is a conflict between the guide and the NDPA, that the NDPA will take precedence. So I would also say that since the guide also gave leverage for either the state or the federal high courts, the party has the option to go to either of them. But since the NDPA is saying a court with jurisdiction, the state high court and the federal high courts have, I would say they have concurrent jurisdiction or joint jurisdiction over data privacy per the laws, per the guide and the NDPA. So any data subject.
Let me ask: will you say there's a lacuna in Section 65 of the NDPA? Will you say that?
Yes, I would say that because there are certain courts in Nigeria that are not courts of first instance, like Mr. Emmanuel mentioned the Supreme Court and the so the Court of Appeal is only court of first instances for election matters, if I remember. So I would say there's a lacuna because the non-specification of which particular court sort of leaves it broad, and the interpretation could mean that anybody could just approach any court in Nigeria. So I think maybe that's what the gate came to cure by now specifying that any data subject can now go to the state or the federal high court for redress.
So do you actually think Gate cured it?
Sorry?
Do you think Gate cured it?
Yes, I would feel so because they specifically mentioned the federal or the state high courts.
No. Does somebody agree?
I have the act is here. They specifically mentioned the federal or the state high courts for a redress.
Hello, Mr. Solomon. Are you still with us? Mr. Solomon, are you still with us? Mr. Solomon is having a little network issue. We would just be waiting a bit to see if he's able to reconnect and join in. If after 3 or 4 minutes, Mr. Solomon is unable to join, we'll be calling it a night on the session, so that we don't get to waste any further time. We're already fast spent on time. So we'll kindly give, I think, 3 to 4 minutes to have Mr. Solomon back on call. If he's not yet here with us, then we'll call it a night. Further questions will be sent to him directly through mail, and we hope that we get a response to him, which will be forwarded to the group or will be addressed in the subsequent class. Okay. I don't think he'll be rejoining us back on the call. I kindly apologize for his absence. Obviously, he made mention of the fact that is in a place where the internet connection is not so strong. So my sincere apologies on Mr. Solomon's behalf. Okay, with this, we've come to the end of today's session. Thank you to every member of the data protection cohort class, right, for joining in for today's session, and to those who are able to stay to the very end. We are happy to have you in class and always, right? So please, we look forward to seeing you in the next session. Come prepared. Ensure to do your research work. I'll be sending that by God's grace, this evening. I'll be sending you the new task for the week with the topic. Please kindly ensure to put in the effort and cite examples and case studies where necessary. Also do well to highlight those case studies when making presentations so that we can have a more interactive session with our mentors where we highlight the case studies and they're able to give their feedbacks in relation to the case studies that were being cited. All right. So good night, everyone. I wish everyone a wonderful night's rest. See you in the subsequent class. Thank you very much.